Welcome to Battle Tested with Tanya Acker. Welcome to Battle Tested. So last week, the Supreme Court handed down a decision that legal scholars are calling the most consequential voting rights decision in a generation. It came out of Louisiana, and it has the power to fundamentally change the way that some congressional districts are drawn. It has the power to shape the next election. We're already seeing some states move to try to act in order to take advantage of what the decision now allows them to do. But what is that? What does a decision allow them to do? What does it mean? Here to talk about all of that is Wendy Weiser. She is the Vice President for Democracy at the Brennan Center for Justice. And she's going to talk about what the Supreme Court did, what it means for you, what it means potentially for the next election and the ones after that. And also, and most importantly, what we all can do to ensure that we retain our power, because we still do have it, trust and believe. Here I am with Wendy Weiser. Don't forget to subscribe to Battle Tested. And very importantly, don't forget to go to vote.gov to make sure you are registered to vote. If you're not, now's the time. Here I am with Wendy Weiser. Welcome, welcome, welcome. Wendy Weiser from the Brennan Institute for Justice. We go back a minute. Thank you for being here.
Thank you.
Gosh, so Wendy and I were in law school together, which was not yesterday. I'll just leave it at that. And I wonder if you look back, Wendy, at that time, do you think that were there things that you sort of took for granted, like when you were a younger, bright-eyed law student that perhaps have proven not to be true now? Like, so for me, I realized that when I was studying to be a lawyer, I assumed that facts would be important to people. And I think that I've been disabused of that. What about for you? Is there something that you were like, wow, I didn't think that this thing would happen?
You know, there is so much that has happened and over the last decade that really was very unpredictable when we were young lawyers. Obviously, what just happened to the Voting Rights Act. I mean, we all thought that the Voting Rights Act was had constitutional stature, that the promise of equality from our Reconstruction amendments, from the 14th and 15th Amendments, were finally realized in law with a huge social movement and bipartisan support. And this was something everybody's learned in school. Everyone thought that that was inviolate, that this was going to be there forever. So what we're facing right now, we didn't think. I also, I've been really disillusioned by the court and the Supreme Court in particular. Over time, I really didn't think that we would see a court that would act and would take steps that really don't feel like judging and would act in non-judicial ways. And whether it's ignoring facts or, misleading or presenting a misleading picture of the facts, or whether it's throwing out longstanding precedent while saying it's doing something else, or making up new ways of doing things. I do think there's a lot of ways that this Supreme Court has been acting that has been disappointing and surprising to many people who were in law school back when we were.
Back in the days of not yesterday. Let's talk about that for a moment, because last week, of course, the Supreme Court handed down a decision in the Calais case, a voting rights decision that you described as, quote, completing its decades-long project to demolish the landmark Voting Rights Act. There are a lot of people who don't live and breathe this stuff. I think a lot of folks are still trying to figure out why it matters, what happened to them. So let's just start there. Let's start with the day of the decision, actually. You're VP for Democracy at the Brennan Center for Justice. Tuesday, April 29th, the decision comes down. What do you say to your team? What's the conversation in the office?
It was pretty quiet. I think that many of us were bracing for a decision like this, but I think there was a lot of mourning going on. I think those of us that have been working on voting issues and democracy issues for a long time immediately grasped the import, the momentousness of this decision, how much of our law and history were being swept away in a single decision. It was somewhat breathtaking, even for those of us that were expecting this. And so there was just a lot of quiet acknowledgement and mourning going on. And so that's what our office felt like.
You got 90 seconds at a dinner party, let's say, with somebody who doesn't know like the ins and outs and doesn't really understand why this decision is important or what it changed. 90 seconds, give or take. What do you say to them?
The Supreme Court just gutted the landmark Voting Rights Act. The Voting Rights Act that was passed in 1965 after widespread movement. People marched for it, people bled for it, people died for it. Bipartisan majorities in Congress came together and passed a law to finally create equal voting rights for Americans and to really bring about a more vibrant and functioning democracy. I mean, it was really effective. And this law that has been holding together like a linchpin of our democratic system and something we all learn about as the crown jewel, the fruits, the crowning accomplishment of the civil rights movement has been brushed aside now. It is essentially all but a dead letter. This is the third decision that the Supreme Court issued accomplishing this, but it is the final one, leaving nothing but a husk of what was previously there. We don't have a Voting Rights Act anymore.
I think that a lot of people don't or may not understand or know or and certainly not remember why there was a Voting Rights Act in the first place. Without getting too deep in the weeds, like let's just do a quick refresher course because we actually had a 15th Amendment that was passed in 1870 and then a Voting Rights Act that wasn't passed until 1965. So let's talk about the 95 years in between. When you are talking to young people, for instance, about the moment that made the Voting Rights Act happen, what do you tell them? Is it Bloody Sunday? Is it what happened on Edmund Pettus Bridge? Is there one story that you think stands out in that 95 years?
The Bloody Sunday on Edmund Pettus Bridge was that straw that broke the camel's back. But it was the culmination of years of peaceful marching and demands for equal rights, especially for Black Americans, especially in the South. It was the culmination of almost a century of brutal repression of Americans, like large numbers of Americans across the country and especially in the South, but not only. And, people suddenly saw the moral clarity of that claim and how we weren't living up to our creed in our Declaration of Independence, the creed in the 14th and 15th Amendments, the promise of equal rights for all. And people said, we're going to actually pass a law that's going to end this repression and actually finally give equal rights once and for all. And it was that moment of the march across the Edmund Pettus Bridge and the bloody repression of that was the last straw, but it was the last straw.
And some of it was violent, of course. And some of it was insidious in other ways. There were literacy tests, for instance, that were required of Black people. There would be exemptions for people who had the right to vote before the Civil War, which was only white people. Mm-hmm. But I have a question for you, because sometimes people say, what's the problem with, asking people a few questions to make sure they know what they're doing when they cast a vote? I would like to know, Wendy Weiser, if you can tell me how many bubbles are in a bar of soap. Could you answer that question for me, please? Because I think our democracy rides on you being able to respond to that.
400,376. And that's the issue, is that whoever hears the answer gets to decide whether or not you get to vote. And the thumb is not on the scale equally for all people. And we saw the result. Actually, Black Americans were excluded from public office, were excluded from the voter registration rolls, were excluded from voter participation for almost a century. And it wasn't, again, just because of the violence, as you said, it was because of the myriad and shifting obstacles that were put in their path every time they were able to mobilize and vote. And this is true for other groups of Americans as well. Speaking, for example, like the Voting Rights Act is not just for African Americans in the South, it is for all of us. It guarantees equal voting rights for every single one of us.
By the way, that, as you certainly know, but just so our viewers and listeners know, that was a real question that was put to a man named Clarence Gaskins, and that was one of the questions on a literacy test that was asked before someone had the right to vote. Clarence Gaskins, true story. Let's just dig in a little bit, but just in a way so that non-lawyers can really get their heads around what happened in last week's Supreme Court decision. So let's walk through it. African American residents are about a third of the population in Louisiana, the state whose voting map was at issue. They had how many, if you recall offhand, how many minority districts?
One out of 6 as it relates to their congressional delegation.
1 out of 6. Okay.
Yeah. And as it turns out, a court found that the denial of a second district where African American voters can elect representatives of their choice was because of discrimination applying the Voting Rights Act. So they looked at the totality of the circumstances and they considered all of the factors, the racially polarized voting, the history of discrimination, the barriers to participation, and determined that the fact that they only had one district where they could elect voters of their choice was due to discrimination. And that violated the Voting Rights Act. And so the court said, you need to remedy that. You need to redraw the maps to provide for equal access, equal opportunity to have representation as everybody else.
They drew up a map that was intended to repair the discrimination, to remedy the discrimination. And then they got sued for the remedy that was intended to repair the discrimination.
And that's right. So a group of white voters or non-African American voters, as they called themselves, sued and said, this new map is discriminatory because it took race into account. Because when you're remedying race discrimination, you should not think about race at all. And you shouldn't be able to consider race. That is not what the law was. That is not what the law has been since the voting rights has been passed and since the courts have been interpreting it. And it would have been a radical change. And when the Supreme Court took this up, and it was when the Supreme Court took up this decision and it broadened the question. It didn't just ask whether or not the Voting Rights Act decision was properly applied in Louisiana. It broadened the question as to whether or not you can ever take race into account in remedying race discrimination, and whether or not, if you want to do so, if there's any other reason that might also explain the maps and the result that you had, whether that reason should trump the race discrimination reason. And what the court found is that essentially they gutted the Voting Rights Act as a tool for remedying discrimination against any voters at race discrimination in redistricting, because it said you cannot take race into account except unless you can prove that it's remedying some very specific act of intentional discrimination. And any other reason, if you say that I was doing it for partisan reasons, or I was doing it to protect my incumbent, including all of the non-Black incumbents that I might want to protect, that negates the race discrimination and we can no longer remedy it.
So essentially what you're explaining is that the court said, if what you say is we're not trying to disenfranchise Black people, we're trying to disenfranchise Democrats, then that's okay.
That's okay, even if all the Democrats in your town are Black. And even if there's racially discriminatory appeals in your in your campaign materials, and even if there's a broad history of discrimination that led the legislature to be constituted the way it was, if currently you're trying to disenfranchise them and you can't prove that the reason you're doing it is because they're Black, then there's no
I guess
case.
we shouldn't say, to be fair, disenfranchised, because you can still vote.
Yeah.
It's whether or not it's diluting. It's diluting.
Yes, whether
the
you
power.
want to deny them their equal voting power and their ability to, it's just removing power from Black voters in the districts that are being, where that discrimination is occurring. They're not going to be able to effectively use their votes to combine them to elect their preferred candidates. They're going to either be spread out in other districts or in some cases packed together so that their power is diluted and they don't get as much of a say as everyone else.
There are two ways in which I think the opinion seeks to address that. And I know you've got very strong responses to both of them. Sort of the first is this question of whether or not the voting power of previously discriminated groups, Black people in particular, continues to be diluted in a meaningful way. And this opinion seems to suggest no. And it cites two examples of cases in which, when the gap between Black voter participation and white voter participation really narrowed. So it seems that on the one hand, the court's saying this thing that was a problem before is no longer a problem. And then the second thing that the court says is that we are not, notwithstanding what Wendy Weiser says, we are not overruling the Voting Rights Act. What do you say to those two big arguments that are a part of this decision?
So the first argument, as you say, is essentially an argument that race discrimination is no longer a significant problem in the voting system and in voter participation. And to support that argument, what Justice Alito, who wrote the decision, said is back in 2008 and 2012, when Barack Obama was on the ballot for president, the gap between white and Black voter participation had narrowed so that they were participating at very similar rates, at least in some states. As it turns out, that was true in a few places for a very short period of time. It is dramatically not true now. The gap in participation between the disparities in participation between voters of color and white voters has not only ballooned, but it has continued to grow each year so that the white voters are voting, the difference in their participation rates has reached almost the highest rates since when the Voting Rights Act was enacted. What we've been able to actually demonstrate is that the reason why the gap in voting rates has increased so much is because of earlier Supreme Court decisions gutting other parts of the Voting Rights Act. We were actually able to prove that the reason why the racial turnout gap is growing is that the protections against voting discrimination have eroded. And in fact, those protections were working, and they were part of what was leading to that narrowing of a participation gap to the greater equality in voter participation. And as soon as we started chipping away at those protections, that gap has increased significantly. And this was actually upsetting to me to read because it is emphatically not true. And there have been many, many studies. The Brennan Center has issued studies, but there have been many other studies since then that have actually demonstrated that this gap in participation has grown significantly. So whatever was true back in 2008 and 2012 for a short blip of a time is no longer true and has not been true for a while and should not support eliminating voting rights protections today in 2026.
It's really worth reiterating that, because the point that you've just highlighted is that during the moment when that participation gap narrowed, That's because there were fewer restrictions on voting. It wasn't just because there was this superhero candidate, Barack Obama, who was popular with Black voters and white voters alike. And I do want to talk to you about that just sort of separately. But there were more voting restrictions. Wendy, can you just explain what some of the more recent voting restrictions have been that may have resulted in that widening gap?
Back then, the Voting Rights Act had multiple other provisions that were in force. One of them was a provision that required states with a history of discrimination to get some approval from either a federal court or the Department of Justice if they wanted to change their voting rules to make sure that those weren't discriminatory. And as it turns out, lots and lots of things didn't happen because they had to seek pre-approval. States and localities would actually edit themselves, wouldn't put in place new measures that would disenfranchise people. As soon as that provision was gutted by the Supreme Court, which happened back in 2013. So that was the first part of this project. Justice Ruth Bader Ginsburg said, throwing away the Voting Rights Act because it's working is like throwing away your umbrella during a rainstorm because you're not getting wet. Lots and lots of new voting restrictions started to pour out. And we saw states across the country pass a surge of new laws restricting access to voting. A lot of them were technocratic. A lot of them don't, we're now hearing efforts by Congress to pass this SAVE Act, which would be a big vote suppression law that would require everybody to show essentially a passport or a birth certificate in order to register to vote. There were things like that that were passing in states across the country as well. But some of them were technocratic, things that would prevent access to voter registration, things that would have a big widespread purges of the voter rolls without protections, where many people, eligible voters, were being deleted from the voter rolls and would show up and be unable to vote. This accumulated, and it has had these new barriers to voting have had a cumulative negative impact.
So let's talk about a couple of those barriers. So what? Get a passport, get an ID. You're an adult in America. The argument some would say is, why is it so burdensome to get a passport? Why is it so burdensome, Wendy?
Well, for one thing, it costs $150.
When I'm paying $7 a gallon for gas, let me go to my money tree and get another couple $100 for a passport. Sorry. Yeah. Go on, please.
Yeah, right. That's right. So about half of Americans don't have a passport. Most married women have changed their names, and most of them do not have a passport or a birth certificate, a passport or current citizenship documents with their with the same name on their voter registration and with their current married name. So if your birth certificate is in your maiden name and you have a new name, if somebody requires your birth certificate or a passport in order to register vote, you have to go through extra steps to prove that that's you, to prove that you can get on the voter roll. So it's not just the passport, birth certificate for 79% of women and 69 million of us. We are going to have to go through extra steps to register to vote. It also turns out that 21 million Americans don't have a passport or other citizenship documents like those that would be required by the SAVE Act. That is a huge number of eligible voters who could be blocked by this legislation.
We don't always have the greatest understanding of what things are like for communities outside of ours all the time. For a lot of Black folks, like my mom, who is, she is getting ready to pound the pavement for these elections coming up because she was born in Mississippi in the Jim Crow South. And for a lot of Black folks in that generation, certainly who were born in the South, it's a lot of work even to get your birth certificate, because when you were born Black in Mississippi in the 30s, documenting your birth was not a priority of the great state of Mississippi. So even getting some of these basic documents is not as easy as a lot of people might assume that it is.
And that's right. And it's also important, it's not just the like the burdens on the documents and the cost of the document, which is true for many people, these bills also have all these other hidden trap doors. For example, you have to show up in person to show your documents to register to vote. Well, most of us register to vote by mail, or when we get our driver's license. We don't go to an election office in person. These bills would be silently overruling all of the ways in which we register to vote. Think about how many extra steps everybody would have to go through in order to register to vote, even if you have those documents. So there are many other trap doors in these kinds of bills that could knock out voters if there's no oversight, if the courts aren't scrutinizing this, if there isn't a way to effectively challenge them. This is a way that you can chip away at the electorate.
What's your response, Wendy, to the argument that, it's hard, we get it, but casting a vote is an important right, and we got to prevent fraudulent votes from being cast? What do you say to the voter fraud argument?
Yeah, well, we absolutely have to prevent fraudulent votes from being cast, and we do. They're just not happening at any measurable amount. We have multiple layers of protection against fraudulent votes, and people are studying and looking again and again. And actually, this Trump administration has been looking for non-citizen voters and gathering up the voter rolls and running them through state databases, and is coming up with no examples of problems, or almost no examples of problems, to proving the point that the system is already very secure. Mistakes happen, even fraud happens, but it happens at such a small rate, and it is actually a crime. It doesn't make sense to do it, and people actually get prosecuted for this crime. You can get caught. There's a paper record. So yes, we need to have strong protections in place. We do. And we can't justify disenfranchising millions and millions of eligible Americans when we've already solved that other problem.
Barack Obama was elected president twice. He didn't get elected because Black Americans were able to elect their candidate of choice. He was elected because he appealed to a majority of Americans across the board. So, and then some of those people who voted for him voted subsequently for a president who I'd say in many, many ways is diametrically opposed in many respects, President Trump. So if you've got people who can say, yes, I can vote for Barack Obama, and then those same people might say, yes, I can vote for Donald Trump, then does that suggest that we have actually reached this post-racial moment that I think is implied in last week's decision?
I don't think that the existence of the Voting Rights Act and the need for it requires us to think that people don't, that everybody is racist, or that people don't cross racial lines or party lines. The Voting Rights Act is there for the circumstances where race discrimination is operating. It is not operating everywhere at all times. And what we know and what the data shows is that in some places, there really is extremely racially polarized voting that is impervious, where this is not working, where people are not appealing across racial lines, and where they are tinged with actual discrimination. That might not be for all time, and it might not be in every election, but there is record after record of this happening, including in Louisiana, in the district that was part of this case. And that is what the Voting Rights Act is there to stop. It's not there to say everything is discriminatory at all times. It's there to say this happens, and it is still happening in America, and it's still happening too often. And where it happens, we actually have a law to stop it, or we had a law to stop it and to remedy it. And it was part of that law that actually helped create this multiracial democracy where we do come together and vote across racial lines and feel like we're part of the same community. And I am worried that getting rid of this law is going to be driving us apart and actually introducing racial wedges. And one of the reasons that I'm worried about this is the court has actually encouraged with this decision partisan gerrymandering and racial gerrymandering. It has actually said that partisan if you have, as we said, if your goal is to harm members of the other party, to gerrymander out Democrats or Republicans, you can use race as a reason to do that. You can go and discriminate on the basis of race if your motive is really partisan. And so it is both supercharging this partisan gerrymandering war that's going on across the country, opening up so many new fronts, but encouraging people to use race as part of their partisan gerrymandering machinations. So this is not going to bring us together. I really do fear that this is going to drive us apart.
Well, we're right now, to your point, we're seeing states who are acting in response to last week's decision by trying to redraw districts in time for the next election, maybe postponing things. I mean, I think, and I'm not trying to make a partisan point here, but the timing of this, like the decision came out in April. And if you follow the court's calendar, people weren't expecting this decision in April. They thought it was going to come a little later. So it was, I mean, do you think I'm overstating the case? I think there was some surprise, maybe, that the decision came out when it did. And it seemed to come out just in the nick of time to get a number of congressional districts redrawn in time for the elections later this year. I mean, did the timing of the decision strike you as surprising?
Yeah, well, it came out actually at the worst possible time. I think there was some thought that if the court wanted to act quickly and allow for redistricting to happen in response to its decision, that the decision might come down in December or January. It had ordered emergency briefing on this case and rebriefing. So there was an expectation that it might act early. And then when it didn't, election preparations were already underway. Primaries were already happening. Some had already happened already. There was an expectation that the court was going to wait till the end of the term, which is the end of June, because they weren't going to issue a decision in the middle of an election season that could throw everything into chaos. So this really is the worst possible time. And what we saw happening in Louisiana is a case in point. When it came down, the governor issued a state of emergency, halting an ongoing election. The primary election for the congressional seats in that state were already underway. Ballots were out. People's mail ballots had already sent in, and the governor issued an order stopping that election. And now they want to immediately redraw the map. It's very possible now a state where a third of the population is African American will have not one district, not one representative representing the African American population after this. So this is, the timing is very chaotic. I'll also add that in the last couple of years, the court has said many times that courts should not issue decisions that impact ongoing elections. They have a special principle that they call, and anytime they issue voting decisions, they say you can't apply them right away. You have to wait until after an election because there's such a high risk of disruption of elections, of voter disenfranchisement, of undermining the elections. So this is very surprising right now because this one is maximally disruptive. It is possible, actually, because this happened in Louisiana. The Supreme Court actually hasn't issued its final judgment on this. So there's still a dispute. The court might still step in and say this doesn't apply yet this year. I hope that that's what the court does in Louisiana. But currently, all of these states are acting like they have free rein to halt their existing ongoing election processes, and they can start over and gerrymander freely in a rush.
Put aside, let's just put kind of the racial aspect of this in a box for a moment, and then just think about what it is the court has said is okay, which is really to kind of legitimize the partisan gerrymander. Doesn't that seem jacked up? I mean, isn't there like, and I say this because, I started our conversation with the reminiscing about our time when we were students, but there was something about the idea that you're supposed to be able to show up if you think you're right, like make your best argument and try to get people to believe you're right because everybody's not going to see things the way that you see them. Everybody's not even going to be focusing on things as you're focused on them. The notion was to show up, make a good faith case so that you could, try to move the needle. Now, like, if you can just gerrymander everything, then, like, what's the point? Like, what's the point of even showing up? I mean, doesn't there seem to be something that is just fundamentally un-American about drawing districts in ways so that the deck's really stacked? I mean, doesn't it just seem wrong? And I know both sides have done it. The Republicans started, the Democrats are followed suit. So we are in a gerrymandering race. But I don't think people like this.
People really don't like it. This is fundamentally super anti-democratic and anti-voter. I mean, this is politicians carving up the country to guarantee certain outcomes and to try to leave us out. We don't get a say. We can't hold our representatives accountable. People understand this. I mean, this is wildly unpopular. This is wildly unpopular regardless of whether you're a Democrat, a Republican, an independent. This is something that has always been unpopular and continues to be unpopular. Banning partisan gerrymandering should be a bipartisan first order of business for the Congress right now. I mean, if the people had a say, that would be the law of the land right away. So I think that there's an opportunity here. I think there's going to be a backlash and voters are going to demand change. It has gotten so out of hand and so extreme right now that it will demand a response and people will be in the streets. I think that there's an opportunity to finally fix this problem. And I do want to say the Supreme Court is significantly to blame for this problem. We've always had some gerrymandering. It's partisan gerrymandering. It's been part of the country, but we haven't had it supercharged like this. And one reason why was there was always a belief that, this is probably unconstitutional. And if we go too far, the courts are going to rein us in. And the courts have always been struggling with figuring out how to find, and the courts always said this violates our constitutional principles. This isn't consistent with one person, one vote, but we don't have a standard yet. So we're not going to let people go and challenge it. And then a couple of years ago in another decision, the court finally said, you know what? Even though all the lower courts were coalescing around a standard, the court said, nope, we don't believe this. The Constitution has nothing to say about gerrymandering. We understand that it's inconsistent with the principles, but courts can't apply standards. We're out of the anti-gerrymandering business. And that greenlit a lot of gerrymandering. But still, we went from this is likely going to be unconstitutional and the courts will rein it in to the courts won't rein it in, but it's still probably unconstitutional to now it's a positive excuse for discrimination. It is encouraged. You can do this. It is constitutionally protected. You have a right to gerrymander and we're going to protect it even if you're doing it in a discriminatory way. I mean, it's so backwards. We've flipped the story exactly.
Do you think that the decision actually does go so far as to prohibit legislative action that would ban gerrymandering? Because I think you're right. I think that there's an opportunity. I think that even though, Texas went first. I think that if you talk to, I'm in California. I think any Democrat in California would have thought it was malpractice for California not to respond as it did. But by the same token, I know a lot of those same people who just hate it. Like nobody likes this. Like it feels icky. So is there still room for Congress to act and say, you know what, we're not going to do this. If you want to win, you got to show up like a grown up, put on your grown folks pants and try to convince people to vote for you. We're not going to build you a district. Is there room for that still?
Absolutely. There's a whole separate provision of the Constitution that gives Congress broad authority to regulate elections. And they can ban gerrymandering today if they wanted to. The Calais decision does nothing to prohibit that or limit that. All the Calais decision did was sweep away the Voting Rights Act and said gerrymandering under our current law is a valid excuse. So they incentivized it. But if Congress bans gerrymandering, gerrymandering will be banned. And that's something that everybody should be demanding of Congress.
So something, Wendy, that I sometimes struggle with when I am talking to people who are not engaged and I want them to engage in the system is that they say everything is rigged, the system's rigged. And I think that if you are trying to encourage participation, you're always like, no, we all have to like stand up and show our voice. This decision does not help that argument. And state legislatures who are building districts to ensure that their favorite side wins so as to dilute the voice of everyday people, everyday voters, that does not help that argument. So help. What do we say? What do you say to people who are looking at something like this, a decision like this, and a lot of the actions that have taken place in state legislatures recently? What do you say to them when they were like, why should I participate? Because it's rigged and somebody in some state capital or some courthouse or some federal building is going to decide who's going to win anyway. Why should I care?
This decision does further rig the system. It puts the thumb on the scale where your voice counts less, but it still counts. And we can still overcome those barriers. And if we show up in large numbers and demand the unrigging of the system still depends on us, the voters. So we just need to work a little harder and show up a little stronger and actually unrig it. So yes, this does make it harder. This is people consolidating power and taking it away from us, the voters. But the whole system still depends on us, the voters. They've knocked us down, but we are not out. And I do think, and even the most aggressive of gerrymanders fail sometimes to produce the outcomes that those rigging the maps expected them to produce, because voters don't always behave exactly as predicted, or voters show up in much larger numbers than people expected. So this doesn't mean that people don't have power. This just means that they've made it a little bit harder for us to exercise our power, but we can still band together, exercise that power, and change that system. And in fact, the Voting Rights Act was actually born out of the struggle of people that had very little political power and that were expressly excluded from political power. And yet they still were able to pass what was one of our most successful pieces of legislation, completely altering our elections and political system across the country. So even with, and we have much more power than that right now. So if they could do it, this is a lesser hill to climb. We can do this too.
3 things, Wendy. 3 action items that you think everybody should take right now. I mean, today, as they hear this, and recognizing that people are busy. People have jobs. This is not a job for most people. Most people are actually trying to work their actual jobs so they can afford gas and food and life. So 3 things that everybody can and should do right now to make sure their power is not further diluted.
Yeah, well, make sure you're registered to vote, and you and everyone in your family that is eligible to vote and all of your friends are registered to vote. Go and make a plan to register and to vote right now. Make sure that that's up to date. 2, we need to actually speak up. What just happened right now, we cannot be quiet at the complete obliteration of the crowning accomplishment of the civil rights movement, at the rigging of our electoral system. Everybody should tell their legislators, their members of Congress, their president, that they don't want this, that they actually want reform now. We want to ban gerrymandering. We want to have real voting rights in this country. And while we're at it, we should be reforming and updating the Supreme Court too, making sure that there are term limits for Supreme Court justices so that people can't have a 40-year project to remake the country, that in fact, that the court better reflects the will of the people and the presidents that appoint them over time. So these are some things that people can demand right now, but get out and actually make your voice heard now.
Wendy Weiser, you have been doing this work for some time. It has not been an easy fight. You have seen sort of key bedrock principles in the civil rights fight and in the voting rights fight fall, most recently as of last week. Why do you stay in this battle?
Because it's the critical battle. This is, if we don't have a functioning democracy that centers we, the people, we can't control what happens to our families, what happens in our communities. We can't have the society that we want. That's our power. That is the fun. That is what makes America America. So this is the fight, and we can't take it for granted. We never could. I think for a while we all thought that, well, look at what a great democracy we have. We are a beacon to the world. We took it for granted. And that allowed people to erode it and to wear it down. But we've been here before, and we've been able to pick it up and to be a beacon to the world. So I believe that we can do this again. We've done this before. And this is the fundamental unit of what makes our democracy tick and what gives us all power. And we can't give up on this fight.
And it is on that note that we will end. Wendy Weiser, Vice President for Democracy at the Brennan Center for Justice. Thank you for being a part of this fight. Thank you for coming onto the podcast, and good luck out there. As you said, we're in the fight. Democracy's in a fight, so everybody's got to stand up.
Thank you, Tanya. It was so great to have you, and thank you to all your listeners, because this is all of our fight. I mean, this is for all of us. This isn't just for some of us.
This is for all of us. We are battle tested, baby. Battle tested. Thanks, Wendy.
Thank you.